not rule of law. So that's how it was back in the day. And it's up in Latin, and I'm not a Latin major. I was just telling you what people told me it was. So hopefully that's what it is. So I'd like to welcome all the citizens, residents, and of course the candidates, and the league for handling this. And what more fitting a place could we have a candidate forum for judges in the original courthouse of Ozaukee County. So at this time, I'm going to turn it over to Barbara, and
away we go.
you're on deck.
Thank
you.
Thank you very much. All right, good evening and welcome to the candidate forum for the Ozaukee County Circuit Court Judge Branch 2. My name is Barbara Hunt, as he mentioned. I am a member of the Ozaukee County League of Women Voters, as well as the president. We have all 4 candidates here tonight participating. Their names will appear on the ballot for the primary election on February 19th. The 2 candidates receiving the most votes will then move on to the general election on April 2nd. Please become informed about your ballot and vote in the primary and general election. Now, before we start, a couple of requests. If you have any personal devices, would you turn them off right now? There is no audio or video recording or photos taken during the forum. However, the entire forum will be video recorded tonight by David Cormerick Bennett, and it will also be posted on our website of the League of Women Voters after the forum, as well as it will be on our blog, which is League of Women Voters Ozaukee, and the Port Washington website. So there are lots of opportunities for you to see this again if you'd like, or to show it to your friends. We request that there's no applauding during the forum, but save your applause for the end of the forum. We would encourage you to write questions that you have for the candidates on cards that are being circulated on each side here, and then give them to the card collector, and that's Barbara over here, and Vanna, and so forth, and they will get them over here to our collators, and the collators will look at them and pass them on to me. If there are 2 that are very similar, then they will combine those 2. Please direct them to all of the candidates, not just one candidate, because if you want to talk to a particular candidate, wait until the forum is over and approach them then. I have to do a little advertising for the league while we're at it. It's proud to be nonpartisan, neither supporting or opposing candidates or political parties at any level of government, and we always work on the vital issues of interest to voters. You know, this year the league is celebrating 100 years since Wisconsin ratified the 19th Amendment, which gave the women the right to vote. And in next year, we will be celebrating the 100th anniversary of the ratification of the suffrage movement, and that was 36 states that took part and passed it in order for it to be part of our Constitution. We have collators over here. We have Jean and Jane. Raise your hands if you're the collators. Okay. All right, now I'd like to introduce the participants of the evening's forum. And we're going to go from this side to that side. So we have Angela Foy, Mark Larson, Steve Cain, and James Wawrzyn. Each candidate will have 90 seconds to make an opening statement. They will make their opening statements in the order in which they're seated. We already determined that order by rolling the dice. Timekeeper is Ellie Anderson. She will watch very carefully how long they go, and we hope that they will not go over their allotted time. The opening statements, however, will be followed by responses to written questions submitted by you, the audience. However, the first 2 questions that we are asking them were submitted by the league and were shared ahead of time with all of the candidates. And they'll have 1 minute to respond to that question. After that's done, at the end of the forum, they will have 2 minutes to summarize their positions on the issues. Now remember again, the league does not endorse any candidate. All of them have chosen to make the extraordinary effort to run for elected office. So as a consequence, they are subjecting themselves to the scrutiny of the voters. Whatever you may think of each candidate's position on issues, They do deserve our respect for their willingness to serve in public office. So we will begin with opening remarks, and the way the dice were, Angela has the first opening remark. Angela?
Thank you, Barbara. I'm Angela Foy, and the primary is 1 week from tomorrow, February 19th, and all of us up here today are asking for your vote. I appreciate this opportunity to share more about myself. I thank you for coming out, for braving the weather, and for participating tonight. I'm currently a shareholder at Hawley & Kao. It's a full-service law firm of 20 lawyers with offices in Mequon, Milwaukee, and Pewaukee. I've been practicing since 2006. I'm married to my husband Ed, and we live with our 3 children, Grace, Roland, and Claire, in Cedarburg. I earned my undergraduate and master's degrees at the University of Notre Dame, and I went to Marquette for my law degree. I'm running for judge because of my own experience at the courthouse. I believe that we have a responsibility to our community to work for change if we believe it is necessary. I was raised to think that if you can make things better, you have a responsibility to work for that change. My qualifications can be found in my experience as a lawyer. I can't tell you how many hearings and trials I've had over the course of my practice. But to give you a snapshot, I looked over the past 12 months, and I've had 118 hearings before 22 different judges, including all 3 of the current Ozaukee County judges. Practicing before these different judges, you learn what makes some better than others. You learn the hard work that it takes to be a great judge. You also see how these judges' decisions impact real people's lives. So that's why I'm running. We have such a great community, and I want to make it even better. I'm committed to working hard for our county. I look forward to further dialogue and answering your questions tonight.
Thank you. Mark Larson.
Thank you. I'm Mark Larson. I have lived in the town of Cedarburg for the past 23 plus years. I have been a practicing lawyer for over 32 years. It'll be 33 years this May. I too graduated from Marquette Law School, but that was back in 1986. And I want to make clear at the very beginning here, I have been part of this community since we've moved here, my family, which I'll talk about in a minute. We really appreciate the community here, and I've been practicing here all the years that I've been in the practice of law, but I've had a statewide practice. I remember coming in this very courthouse and practicing in front of Judge Charles Larson, who's not a relative of mine, but he was one of the first judges I ever appeared in front of. There was Walter Sweetlick. I used to work originally in his brother's firm. So I have a lot of connections to this courthouse, but certainly over the last couple of decades to this community. And I want to make a point that the reason I'm doing this is a sense of responsibility to this community, and not just an opportunity that I saw out there for myself. We know there were some issues. I thought this is with my experience. I've been a trial lawyer all those years. I've tried dozens of jury trials, not just court hearings, not just trials to the court. And I've tried cases over a wide variety of things, and I've seen what happens with jury trials. I've seen things what happen during the motion hearings. I've seen good judges. I've seen really good judges. Thank you. That seemed awfully short, but all right.
Can you hear me in the back? Thank you to the league for hosting the forum. Great turnout again, as it was last week. So I'm Steve Cain. I'm a 16-year resident of Cedarburg. My wife Heather and I reside there with our 2 boys, middle school age boys who are in middle school in the Cedarburg Public Schools. I've been active in the community since I started practicing in Ozaukee County in 1999. I've been involved at the board level with Big Brothers Big Sisters, the Volunteer Center. I'm a past president of the Cedarburg Grafton Rotary Club. Professionally, I started practicing law in 1999 with the Houseman & Fine law firm in Grafton. Did that for 10 years. And then the last 10 years with Stippage, Saline & Cain, my own law firm with 2 partners in Milwaukee and now Cedarburg. And I've had the great honor the last 10 years of serving as the Mid-Moraine Municipal Court Judge, which is the municipal court that serves Ozaukee and Washington counties. So I'm running for Circuit Court Judge because I care deeply about Ozaukee County and its justice system. I think I'm uniquely qualified based on my private practice and my judicial experience. I believe wholeheartedly in a judge's role as a guardian of constitutional rights, as a participant in the public safety aspect of the job, and as an arbiter of facts to help the public resolve disputes that may come before the court. So Again, I think I'm uniquely qualified for the position, and I appreciate your questions tonight and ask for your consideration. Thank you.
James?
Thank you. I am James Wawrzyn. I live in Mequon with my wife Val and our 2 kids. We're also fostering a 4-month-old baby girl that we're hoping to adopt. A couple of years ago, I started to see the headlines of what was happening at the Ozaukee County Justice Center. And perhaps like many people in the room, I thought to myself that something didn't seem right. Something was off. And having had the opportunity to read the Department of Justice report on the Ozaukee County Judiciary, those thoughts were confirmed. And I thought that as an attorney, I currently practice at Fundraising and Roper, represent businesses in both litigation and transactional matters. But I also thought that as someone who had experience working in all 3 branches of Wisconsin state government, where I had an opportunity to develop a feel for how the judiciary should operate. And that was as criminal justice policy advisor to Governor Thompson and Governor McCallum, and then also as clerk to Justice Wilcox. So my thought was, as a voter, a concerned voter of what was happening in the Ozaukee County Judiciary, perhaps it's time for a fresh start. Perhaps it's time to have someone who doesn't have natural courthouse constituencies, but instead has that appreciation for the judiciary.
Thank you very much. Now we're going to go with the first 2 questions, which came from our league, asking each of them. The first question is, and we'll go to Mark first, is what do you believe are the most important factors for voters to weigh when selecting a circuit court judge? Mark, you're first.
Well, I think 3 very important qualities that a judge needs to have is, first of all, people skills to get along with and communicate with people in their courtroom, but the other people in the courthouse. There's also, obviously, you need the legal knowledge and legal skills, but a lot of it has to do with experience. Clearly, in order to know how to manage a courtroom, you have to have been in the courtroom and proceeded in front of the judges and seen how things operate properly, and when things go bad, what needs to be done to correct those types of situations. So again, I think the fact that you have to have the experience trying jury trials to be a proper circuit court judge, because that's probably the most complicated and important aspect of the court's proceedings. The other thing that I think you need to do is, obviously, you need to treat the parties that come in there, and that goes to the people skills. You've got the parties and their attorneys that you want to have them proceed properly in front of the court so that they don't waste anybody's time and money. Sorry about that.
All right. We're ready for the last person, James.
Does Steve go or do I?
Steve, you're listening.
Okay.
Okay. Well, I'm here asking you for your vote. You're essentially the HR department making a hiring decision. And the public, because most of you probably don't have much, if any, experience with the justice system, are really in the dark. And that's what's great about a forum like this. But I think if we kind of looked at a job description of what's necessary for circuit court, I believe jury trial experience, as Mark mentioned, is key. I have that. I think experience in criminal law is key. I think the statistics show that about 50% of what a circuit court judge in our county, what they do is criminal law. So experience as a municipal prosecutor here in the county, as someone who's done some defense work, someone who's been intimately involved in OWI cases, these are the nuts and bolts of what happens in the courthouse every day. And combine that with my judicial experience, I think these are qualities that are really necessary to do the daily work that we do at the courthouse. Broad legal experience. My practice at Houseman & Fine as a young lawyer was forced to be broad because they wanted to build good lawyers who had a broad smattering of experience, and I think that is key for the general jurisdiction court that circuit court is.
All right, now James.
I think one critical factor, the most important factor, is being impartial. So that whenever the parties are in front of the judge, they know they're getting a fair shake. And I think part of that is, and unlike the other candidates, I don't have extensive jury trial experience. You've heard them note that that's some of the most important experience you can have. I disagree with that. I think being impartial and being able to hear each case without favoring one side over the other is paramount.
Thank you. Angela?
Thank you. I expect that each of you weigh factors differently, but I can share with you what I look for. Part of that is leadership qualities. That's the intelligence, the respect, the impartiality, the ability to communicate. I think it's experience in the courtroom. It goes to that jury trial and bench trial and many, many evidentiary hearings. And it's also a variety of experience with the law. The general jurisdiction that Ozaukee County has, you have to be able to deal with all types of areas. And that's what my practice has been. I've represented service members while they've been deployed overseas. I've helped parents adopt their children. I've fought for individuals to get protection from their abusers. I've assisted entrepreneurs in forming and protecting their businesses. I've helped families through the probate process after losing a loved one. And I've met with a client in maximum security prison in Waupun. The law isn't always what people want it to be or hope it to be. The judge has to make difficult decisions and be able to explain why she made those decisions.
Thank you. The second question is the ongoing discussion about whether judges should be appointed or elected. Where do you stand on this issue and why? We'll start with you, Steve.
Well, the Wisconsin Constitution requires judges to be elected. To change that would require legislative action and the matter to go before the people on the ballot. So the process to change that obviously is not a judicial determination, that's a legislative and ultimately the people's determination. So there'd be some significant hurdles to get to an appointed situation. I did a little research. 39 states seem to elect judges at certain levels. 11 have judicial elections that are partisan. And in some of these states that have appointments, they're done by a bipartisan board or committee that appoints judges. And as I boil it down, again, this really isn't my opinion to make. It would be a policy decision. But I believe in we the people making the decisions. We the people can hold elected officials accountable versus we, the appointed, unelected board who appoints a judge. So I think if we focus on we the people, I think that makes the most sense.
James?
I think the current law, which Steve mentioned, is in the Constitution, which requires that judges be elected, is good law. In that, I think it's positive that we can have gatherings like this, where interested voters can inform themselves and make decisions to ensure that the candidates are representing what the voters value, rather than having an appointment process that may be more favorable to courthouse insiders or political insiders or other people that have more connections. So I think that providing voters the opportunity to weigh in on judges is good.
Angela?
Thank you. I think the election process is critical. It gives candidates the opportunity to challenge a judge if they disagree with how they're conducting their duties. Of all of us sitting up here tonight, I filed to become a candidate first back in October. And at that time, I was challenging a sitting judge. He didn't decide until the end of the calendar year not to seek re-election. And after that announcement, I think additional candidates joined in because there was an open seat. What I did know was that our county needed a change, and I'm still committed to bringing that change. There were no deals cut for my candidacy. I didn't seek any endorsement until after I had filed my election paperwork with Wisconsin Elections Commission. And from then to now, my commitment remains to try to improve the county. The election process is good for our county. Healthy competition among the four of us will push each of us to bring out our best. And I think that because judges have to face re-election, I think it helps them work hard too.
Thank you. Mark?
Thank you. In one, I would disagree on the timing of things. I was also an early candidate, and I think I had actually started the wheels in motion a long time ago in this process because there was clearly an issue here. There was a problem that needed to be addressed, and regardless of whether it's all one person's fault or another, there was a dysfunctional system going on here, And it's caused problems, and it continues to cause problems still. And one of the things I wanted to make a point about when this issue was presented to us is just think about this. If this was an appointed judge situation right now, would we have a remedy to the situation we've already had? The incumbent in this case realized he was facing serious challenges to re-election and decided not to run. So the fact that we have an elected judicial system here has actually worked already. There was a problem, and the problem, because of just the mere fact a couple of us we had gotten out in front and decided we were going to challenge an incumbent, it worked. Thank you.
All right, thank you. All right, now the next question comes from the audience. So, this is the question. Why do you want to be an Ozaukee County judge? And James, we're going to start with you.
I think Ozaukee County is an incredible community, and based on my experience, I think the judiciary plays a critical role in any strong community, and that includes dealing with cases to make our community safe. It also includes adjudicating business disputes and providing clarity so that people are permitted to prosper. So it's really, after having a unique blend of public sector experience and private sector experience, a call to a point where I can serve this great community in a way to enhance our judiciary system.
Okay, Angela?
Thank you. I want to be an Ozaukee County judge because I believe I'm driven by my sense of responsibility to work to improve the county. I believe I have the experience, the legal expertise that is needed, and I can work hard to make that change. I can't sit by and not take action when I see the potential. We have such a great community. I love it. I fell in love with it when we moved here more than 10 years ago. And I can't sit by and not take action when I see how much better we can become.
Mark?
Thank you. One of the things I was going to indicate earlier, we have a lot of roots here in the family, of our family in the community. I indicated we've been here 23 years, and we've really established connections. I'm the president of the Fair Board. I didn't get a chance to talk about some of our other activities that I've been involved with here. And all those years, I have 3 decades of being an attorney, trying cases across the state. And when there was an issue here, I thought, I'm in a position in my life where I have a lot of experience to offer. My family's here. I consulted with my wife and my children. My youngest daughter has graduated from college. So I was in a different position where I can commit myself to public service. And I'm not going to be compromising anything or my responsibilities to my family. So I thought one of the things I wanted to do, I really enjoy the opportunity of serving this community. And I'm in a position to do that, and I was in a position to address a problem that we've already discussed a minute ago. But that's why I wanted to be a judge, and I continue to want that same goal.
Steve?
All right. Well, for me, it's a professional and personal calling. When I was 34 years old, I ran for municipal court judge for a court that, too, was struggling with some public issues. And I was young and had the experience necessary, and I was thankfully able to be elected. And for the last 10 years, it's kind of like baseball. I've been in this proving ground for the last 10 years to develop myself as a judge, to make decisions, to hear over 1,000 contested cases, to be in this position today where I have something to offer to the county. And I was encouraged by so many in the legal community and just the community in general to do this. So it's really a pursuit of a calling from the encouragement of many who know me and my work.
Thank you. All right, we're going to another question. This is a long one. The majority of the residents of Ozaukee County have probably never even met any of the candidates for judge. So how do we, the people, know that each of the candidates will be fair and impartial? Now, should judges be required to be recused from any case in which they can be presumed to be a subject of it, or subject to undue influence from a wealthy benefactor or an influential vested interest, should the judge decide alone. And Angela, we're going to start with you. Do you want me to read it again?
I think I got it.
Twice.
I recognize that a majority of you haven't met us individually, and I appreciate this opportunity and an event, something tonight, so that you can hear from us directly. You can see what values we each hold, what kind of directs our lives. It's been one of the great parts about this campaign. I love getting to meet the people who are going to be deciding this. Between the one-on-one meetings, going door to door at different events that we've had, it's been a great interaction, and I get to hear what's so important to you. Regarding whether the judge decides whether you recuse yourself or not, there's some pretty strict ethical rules that would govern what a judge does, what the judge decides, versus what an attorney will bring up and raise. I've taught some of the ethics credentials at continuing legal educations to lawyers. Judges are bound by those, and then some additional ethics rules, and that's going to govern what can happen so that a judge wouldn't rule over something where they had that vested interest.
Thank you. Mark?
Well, I hope in the 23 years that we've been in the community, I actually have met a lot of people across the county by being involved with the county fair board and helping operate that over the last 8 or 9 years. I've had an opportunity to meet a lot of people. I teach hunter safety several times a year here in the county. I've been involved with the 4-H program as a leader over the years. I've been involved with my church as teaching Sunday school, doing youth trips with multiple churches in combination. So I've tried to be part of this community without ever having any interest in trying to step forward and run for any kind of particular office. To address the conflict issue and to explain things, number one, there are some strict rules. If the judge has a personal interest or any blood relative has an interest in the outcome of a case, they have to recuse themselves. Beyond that, there's an old case with T.V. Lenny, and you may remember that, involving the Supreme Court justice. That case brought out a rule that basically if the judge, it's the judge who makes the decision if they can be impartial or not. Now, thank you.
Steve?
Well, obviously, being sensitive and aware of what's going on in your community is key to this role, because any judge, in many respects, is the voice of the community in certain situations. So being active in youth sports, running my boys' Cub Scout pack, being involved in boards like Big Brothers and Rotary and the like have all obviously given me a situation where I can feel, I guess, the pulse of the community. As far as, again, we've heard there are obviously SCR 60, there's judicial rules of conduct that deal with the recusal issue, and when all else fails, if there's any question about recusal, then the easiest thing to do is recuse. If there's any question or you feel like the parties have any concern about your ability to be impartial, you can recuse. And when there's lawyers involved, the best thing to do is raise it with the lawyers. Tell them what you feel the issue is, and give the lawyers a chance, or the litigants, to weigh in and say, Judge, no, we think you should go, or Judge, no, we're comfortable with you moving forward.
James?
Yeah, I think, I mean, again, throughout the campaign, you get the opportunity to meet more people than you would think and engage with more individuals. And there are occasions like this where you get to get a better feel for the candidates. Beyond that, just from a kind of government regulation and protection standpoint, as far as, you know, interests that may influence a judge, I mean, we do have campaign finance laws. You can see who's given to which candidates and which the source of those contributions. We also, as has been mentioned, we have judicial codes of ethics. And so I think, in part, we have apparatuses in place within our system to be a check on that. And that ultimately, we have rules of ethics for judges, just like lawyers, that can give voters comfort that impartiality is applied.
Thank you. Mark, this new question will be for you first.
Okay.
What do you see as the most pressing issues associated with juvenile justice in Ozaukee County?
Well, with juvenile justice, that's one of the areas where there are, in fact, jury trials. But importantly, the most pressing issue is substance abuse issues. We have to come up with a better system of dealing with those issues as a society. Unfortunately, a lot of it ends up in the courtrooms. We've got the opioid issue, but we also, as we probably, maybe somebody here isn't aware of, the alcohol issue in this county. There was a fatality just this weekend involving alcohol, unfortunately, with some of the residents of this county. That is something that I think needs to be addressed. It takes a lot more, than just the judge setting down sentences, but we need some more structure with regard to programs that will help people who get involved with substance abuse issues, especially very young and early in their lives, so that they don't go on to a lifetime of having to suffer and deal with these issues and be a burden on society.
Thank you. Steve?
Well, my experience in municipal court is unique in that municipal court deals with young people ages 12 to 17, that's the juvenile category. And most of the kind of the basic juvenile matters come to municipal court before they end up in circuit court in a criminal status. So I've had this kind of, and these hearings are all private, so I've kind of had this unique window into the reality of what's going on in our community. And I think the biggest crisis with young people we have is a mental health crisis. In addition to obviously substance abuse. But we need to, judges, when we're dealing with kids, we need to make sure that we're imposing sentences where we're getting these young people the right services. And that means leaning heavily on our county social services. And being a cheerleader. More often than not, we need to be a cheerleader for these young people and give them encouragement along the way. Encouragement and obviously the threat of the carrot and the stick type of thing, but we need to be cheerleaders, especially for young people in crisis situations.
James?
Juvenile justice is one of the key areas I think that circuit court judges deal with, in that it's an occasion to hopefully identify issues early and take steps to straighten people out. And I had the opportunity to work on the Governor's Juvenile Justice Commission. We did a lot of work hearing from different counties on reform efforts they had made to enhance juvenile justice. I think one of the key areas, perhaps the most important, is at the state level, the juvenile justice system in Lincoln Hills, and for those cases where juveniles do need to be detained, making sure that we have facilities that are doing what they're supposed to, rather than being in the condition that they have been.
Angela?
Thank you. Juvenile justice is a pressing issue to try to make sure that the right access to these young individuals understand the process, understand that it's a critical point in their life. There are other factors that impact why they're there. Some of it's substance abuse, and those are some big things that we can address with the justice system. It takes involving the whole system, though. It takes social services, it takes people. We've looked at drug courts. Waukesha County has done a great system, and they've proven some great feedback, and I think it's something that we can look at. I've seen it work well there. Mental health issues are significant, and I know our undersheriff, Christy Knowles, has been instrumental in initiating the crisis intervention program to train sheriff, police personnel to recognize mental illness so that they can see it right away, so that we can tackle those issues with it.
Thank you. Another question we have is specifically mental health issues, but several of you have addressed those, so I'm going to put that aside for now and go to this question. And the first person for this question will be Steve Cain. What is the appropriate use of cash bail for criminal offenders?
Well, this is an issue that's kind of a hot topic in the last few years, and cash bail's purpose is to ensure that a criminal defendant returns to court after they've been initially charged with an offense. That's goal number one. Goal number two is to ensure that the public and any witnesses are safe and that is done with imposing conditions on those persons. So cash bail's purpose is not to incarcerate them and hold them pre-conviction. It's to ensure that they return and then impose conditions to make sure that the public and witnesses are safe. So when we're dealing with people's liberty, there is a fine line that we need to make sure that we are not punishing the poor for not having the ability to pay bail and rewarding the rich to be able to pay bail. So we need to be very mindful of that. When we're dealing with people's liberty, it's an important decision, and we need to follow the law that we are trying to get them to return to court and keep the people safe.
James?
Cash bail should be used to get the accused to return to court. And I think that one aspect of the discussion and debate around this issue is how long are people being detained awaiting trial for charges that they're accused of. And I think that's where having enhanced efficiency in our system, taking steps to make sure that we are focusing on speedy justice so that people are getting their day in court in a more timely manner would alleviate some of the concern related to bail and related issues.
Angela?
I agree that cash bail, the purpose is to make sure that people return to court, but I think primarily it's that safety that the judge has to assess at that point in time. Is everybody going to be safe kind of while this is going on? Efficiency is key, because the faster we can resolve these issues, resolve the case, it's going to matter. Another option is that signature bond, right? I'll have other people sign too if that one individual isn't, if the cash bond, the cash bail itself isn't significant enough. So there are different tools, but it's balancing the facts of that specific case, how quickly we can resolve the matter, and also the first and foremost is that safety of the community.
All right, Mark?
Thank you. I think the question really went with the cash bail and that all the conditions associated with it. And I know one of the issues that has recently come up was, we've done away with the bail bondsman system years ago, and now people are seeing the abuses and the burdens that are shifted to families, especially, who come up with the money so that their loved ones can afford to pay the cash bail. And that places a burden on them, especially if their loved ones then don't comply and that bail is forfeited, which has really been an exposure to a lot of people, and it's created a lot of hardships. Now, the bail bondsman, what people don't remember was that was a system that was very abusive, because it was kind of a usury type of system almost, where you could get that money for the bond, but there was a large penalty to it. It was very expensive. But I know just recently there was a discussion about returning to that system as a way of easing some of the burden and the exposure to the family. So that's more of a legislative issue.
Thank you. What alternative choices, and this will go to James first, what alternative choices will you use in your judicial philosophy to counteract behavioral problems of substance abuse offenders? So what alternative choices will you use in your philosophy to counteract behavioral problems? James?
A key aspect of my judicial philosophy, just from the practical standpoint, is to treat everyone professionally and with respect. And so when someone appears in the courtroom, to show them the courtesy that all parties are shown. To the extent that there are mental health issues, decorum issues, I think just having clear standards for behavior and taking steps to make sure that everyone is getting a fair and impartial hearing.
Could you just repeat the question again, please?
All right. What alternative choices will you use in your judicial philosophy to counteract behavioral problems of substance abuse offenders? And Angela has this.
Thank you. Substance abuse is a unique issue because there's so many factors that play into it. There needs to be consequences for actions, but they don't need to be the same consequences as a violent offender. And so that's something to take into consideration. As I mentioned, Waukesha's done this drug court and found that buy-in from the whole community can be very effective and less expensive. So it's something to take a look at to see if that's something that we can do. But that does take buy-in from multiple people, not just the judges. It's the DA's office, it's the public defender's office, it's multiple departments within our county. I also think that the biggest part of being a judge is to be that impartial person and to apply the law to the situation. You have to be consistent. And so developing what that is within the guidelines that we have, that's what you need to do.
And Mark?
I'm not quite sure I perceive this as a philosophy issue as much as, especially with the judge, you have to understand that the judge is going to be operating within a system. We're applying the laws that exist. We're working with the structures that exist currently. Now, that's not to say that the judge shouldn't be proactive in working with the county and the state and trying to set up alternatives, like we've heard several times, drug court types of situations are alternative processes here. That's something, but right now, the circuit court will have to deal with the structure that's in place. Now, having said that, you have to look at the factors like the environment, take into consideration the individual cases, see that the process here and that the departments and within the county are best utilized, and then whatever other programs that are available that can be utilized to get those people out of that cycle. And obviously there's the environmental issue. If they return to the same environment, there's good chances of returning to using again. So there's a lot to this, and thank you.
Yeah, well, big question. I mean, there's the newspaper article a few months back about the fact that our jail is full and talk about expansion and that the people that are in there have largely mental health and substance abuse issues. I sit on the Criminal Justice Collaborating Council for the county, and recently we had a visioning session with the Washington Ozaukee Health Department, and we were talking about strategies to, one, try to alleviate some of that jail population and get people treatment who need it. Focusing on giving people Vivitrol shots, which you may not know of as a shot that counteracts opiates, as part of their release program to make sure that they can stay clean for a period of time. The county has been great in pursuing that. And we've talked about the possibility of a drug court. Most counties have it, we don't. Washington County's just getting one recently, and as I mentioned, to people on the CJCC, I'd be interested in exploring that, visiting other counties to see if that's something that we could do here. And that's a wraparound program with regular court appearances for people to make sure they're getting treatment and wraparound services. So I think that's key to this particular issue.
Thank you. New question, and this will be starting with Angela again. And again, we're in kind of the same mode here. What are your thoughts about crimeless revocation? Being sent back to prison because of breaking a rule, but not committing a new crime? Should I say it again?
Yes, please.
Okay. What are your thoughts about the crimeless revocation, prisoners being sent back to prison because of breaking a rule but not committing a new crime? Okay.
Revocations often happen in front of an ALJ in jail, in prisons, wherever they are. And then they can be de novo to the circuit court judge. And so that's where it would come across our desk. And I can't tell you exactly what we would do. None of us can say on a specific case what exactly we would do. But obviously there's different factors that you have to consider in what would happen. And you have to weigh that. Like I said before, I don't think that non-violent offenders should have the same consequences as violent offenders.
Mark?
Thank you. Well, and that would be the point. You got to take into consideration, are we talking about endangerment of life here? Are we talking about, what's the specific issues that are involved that cause the revocation? Clearly, we're getting back to some of the substance abuse issues. There's some people whose bad behavior has always been tied to substance abuse of whatever kind, and so they're restricted from the use, and that can lead to a revocation of itself. So you have to take into account what the specific factors are. Now, the biggest trick is obviously there's no litmus test when you apply it to an individual that comes before you. Is this someone deserving of a second chance, Or is this someone who has to learn with a little more of a firmer lesson than maybe they previously responded to or received? So that's really the issue here. You're going to have to take it on a case-by-case basis. I don't think anybody here would be capable of putting forth some real strict rules that they're going to apply, regardless of who it is in front of them or what the circumstances are.
Steve?
Well, probation, the sentencing, the law in Wisconsin is that probation is the preferred type of sentence to give someone. Depriving them of liberty comes second for other reasons like protecting the public and not depreciating the seriousness of a crime. Judges at the circuit court level, either when they're using probation as a sentencing tool, they either use it, they either withhold sentence and put someone on probation, which would give them the opportunity, if the person was revoked, screwed up, to come back and then the judge would get to sentence them. There are other scenarios where judges can impose a sentence up front, and if the person screws up, that's the sentence that they get. So ultimately, the decision to revoke falls largely on the Department of Corrections, and I think the statistics recently is that they're being a little more lax on revoking for ticky-tack things, like I'm hearing in the question here. But if someone is revoked and it's a withheld sentence, they're going to come back to the court, and the judge will be able to make a sentencing decision taking into consideration what the offense, ticky-tack or otherwise.
James?
Sentencing is one of the most critical roles that a circuit court judge plays in figuring out what the appropriate sentence is, in trying to decipher what type of sentence is necessary for a particular situation. That being said, with revocation, when those decisions are made, I give a lot of respect to the sentencing done by judges as far as the conditions that are imposed by the Department of Corrections. Those fall more into the realm of policy, which is something that I was more involved with when I worked in the governor's office for Governor Thompson and Governor McCallum. But for Ozaukee County Circuit Court judge, that would not be as applicable.
Thank you. We're going to go on now to the next question. Oh, did you get a chance to answer that? Yeah. Okay, this is kind of in the same realm again. What is your approach to criminal sentencing and the use of expungement to clear records of offenders? Okay, and Mark, you will start with that.
Yeah, can you read that one more time?
Okay. What is your approach to criminal sentencing and the use of expungement to clear records of offenders?
My understanding with expungement is that is to be used in limited situations more so. Certainly you try to do that, it applies really in the situation with juveniles would be the first situation. But I understand where you'd want to have the opportunity to have your record cleared. There's actually the process through the governor's office that's been utilized, getting pardons at certain points in time. But I mean, the problem I guess I would have with expungement being utilized in a very liberal sense is if you're doing that, we have habitual criminal penalties as well, and so I would think that would interplay with that in one situation. Again, you'd have to look at the case-by-case basis as to what would justify expunging that conviction from someone or that record. We do have laws in Wisconsin that prohibit the discrimination in an employment setting for people who do have criminal records. Those are very rarely enforced correctly.
All right. Steve?
Well, Mark mentions the laws barring discrimination for criminal records. It happens all the time. People go on CCAP and discriminate against people all the time, and that's why young people who have maybe made a screw up when they're 17 years old, we need to remember that 17 is an adult for criminal law here in Wisconsin, not 18. So a 17-year-old could screw up, minor drug offense or something like that, and perhaps destroy their future and their employability. So expungement is a tool in the law to allow judges to evaluate whether this person is a good candidate and whether it's in the public interest to give this person a second chance after they've completed some sort of sentence. I think it's a great tool in the right situations, especially for young people. But obviously, we need to be mindful and not do that across the board. There was a great study by the WPRI, now the Badger Institute, about the use of expungement and how it could help employability and getting young people back to work. I think that's key. And I'm done with my time. It's a great question, though, and it's a pressing issue right now.
James?
Expungement is something that would need to be considered on a case-by-case basis versus a more generic policy position for any judge. Again, as facts and circumstances arise, certainly that is an option. I served on the Governor's Burden Advisory Board. I had the opportunity to hear from people that had criminal records and were seeking clemency for various reasons. So I've been part of those deliberations and applying those standards on a case-by-case basis.
Angela?
I think expungement can be appropriate, but only in very narrow circumstances. As you've kind of seen from everybody talking tonight, there are some instances where it may be appropriate, but it's a balancing effect. There's a reason why criminal records should be out there and why people may need to know about them. That has to be taken into account. I filed motions. I've sought expungement of records, and I've also fought against the expungement of records. And so it really depends on the specific scenario and what may be motivating, what may be the reason they're seeking the expungement, but also what are the other factors of how it would affect the community.
Thank you. All right, we are now going to go to another question. As we all know, it is vital in this judgeship to have a respectful relationship with the district attorney. Could you kind of discuss that situation? And Steve, it would start with you. Relationship with the
Sure.
the district attorney.
Well, having practiced in this county for 20 years, obviously know a lot of the players in the system, district attorney including one of them. But he serves a role in the adversary process just like a defense lawyer does, and he's no different than anyone else. So when seeking endorsements or receiving endorsements from people, the district attorney is endorsing me, but I also balance that with some of the most premier defense lawyers in the area in Metro Milwaukee. So relationships with people in the community, fine. Obviously, we have relationships, but that can't come into play when we're dealing with cases in the courtroom. So that's why I've sought to have a balanced approach. Plenty of defense lawyers who support me in this race, district attorneys and other prosecutors, even in other counties supporting me. But again, there's a balance there, and again, no favoritism for anyone. It's an adversary process, and we look at each case in its individual capacity.
James?
I mentioned at the outset that I'm sort of running as an outsider, as a fresh start. I don't have a relationship with the district attorney, and I think that would be positive in that impartiality. You know, I would not be more inclined to make any decisions based on existing relationships. And I think that's the role of the judge, to be impartial, to not be catering towards certain courthouse constituencies.
All right, Angela?
The district attorney is one attorney that would be before you as a judge, but just one attorney. And so you have to have a respectful relationship with the district attorney, with the assistant district attorneys, but you also have to have that respectful relationship with the other judges, with the courthouse staff, with the other attorneys that come before you, with the pro se litigants, whether they're represented or pro se. You have to be respectful of everyone that's in front of you, including the district attorney.
Mark?
And that's exactly right. The district attorney has his role. There are other attorneys, obviously, who are going to be adversary to him that have their role. The role of the judge is not to favor one side or the other or to have developed a special relationship with one of the parties. It is to be fair with everybody, to apply the law correctly, to apply it logically and reasonably under the circumstances, and to make sure that everybody has an opportunity, due process, to be heard and present their side of the case fairly. And you cannot in any way, shape, or form have a relationship that would, swayed the jury that you think you are favoring one side or the other. That would be improper for a judge to do. You have to be incredibly impartial and equally apply the law to both sides in that situation. Judges are not supposed to be looking to try to drive an outcome in a case. The finders of fact in that courtroom, in a jury, in a criminal setting, are going to be the jury. And then the judge applies the law to the findings set by the jury.
All right, James? No, I think we're done with that.
Yep.
All right, so now we're going on to another question. Did I get everybody on that one? Okay. This is a little twist again. How much time do you think a judge takes or should take to review the materials and evidences of a case before all the parties appear in front of the judge in the courtroom? Preparation time. All right, we'll start with you, James.
I think preparation is one of the key aspects of being a great judge. I was chatting at a function with Judge Brennan, who's now a federal court of appeals judge, and we were talking about his time on the circuit court in Milwaukee County. And I was just kind of picking his brain on kind of what he did to be such a great judge. And he talked about preparation, being ready whenever the cases are called to make a decision. Because I've been involved in cases and been in front of judges, or the judges, for whatever reason, and maybe they're dealing with other things, they weren't ready to make a decision. And then having to explain to a client that they were going to have to wait for another hearing. Those sorts of delays inhibit our judiciary. So I think preparation is one of the key aspects of being a great judge.
Angela?
I think preparation is key. I think it's one of the things that will make judges better judges. Not every case involves briefing, but if the parties go through the process of briefing, reading that material before coming out, before a hearing, is crucial. It's obvious, it's evident to lawyers when a judge hasn't read it, when they haven't read the file. It's different than the evidence, right? But to know the file, to know what you're there for that day, to know what the law is and what each position and what actually needs to be decided is something that's critical. And it takes work, but it's very, very important to those parties who are appearing before you. The evidence piece is different. That's going to be presented at trial. And that's something that you have to be very diligent about and paying attention so that you can weigh it and factor it in appropriately.
Thank you. Mark?
I can tell you there's nothing more frustrating than to go into the courtroom and both sides are prepared on very complex cases. And I want to tell you, what I typically try tend to be really large cases involving death or real severe injuries. And so we've got a lot of complex legal issues, evidentiary issues, and we go in there, and if you have a judge who has not been prepared, I mean, it circumvents the whole system. And it makes it very difficult. It makes it hard on the juries who are hearing those cases as well. So it's really key to be not only to have read everything, but to understand everything, have thought about what you think are the unanswered questions that are presented to you, so that when they come in for that hearing, you have pertinent questions to ask them. I just argued from the Supreme Court a week ago from Friday, and that's the type of thing. You've got a very brief period of time, just like we do here, and you have to respond to those questions, but the judges have to be prepared to make that meaningful so that they can then apply the law to the facts for reasonable decisions.
Well, really, it's a case-by-case evaluation. Much of what the circuit court judge would specifically not allow you to prepare for. If the court is going to be a finder of fact, you don't want to be predisposed to certain facts about the case. You need to be a clean slate. So there are types of cases where you're going to wait for the evidence to come in and make your decision based on what the evidence is, and not look at any information that may be available to you. That's key to being impartial in many of the cases that we would see in circuit court. And the other thing about preparation is requiring lawyers, being on top of the lawyers to make sure that they are preparing and getting you prepared for their cases, right? Making sure that they're following scheduling orders to get things in a timely fashion so the court, yes, has ample time to prepare, read briefs, and give a decision on a date set. So really a case-by-case basis. There are scenarios where zero preparation is the right approach, and others where as much preparation is necessary to be ready for those lawyers or those litigants on that day.
Thank you. Next question. We're going to start with Angela. What does the term conservative mean in a nonpartisan race?
Conservative can mean many things to different people. I recognize that people will read into it what different connotations that they bring to that term. Our race is a nonpartisan race, and that's what it's supposed to be. To me, I think of my family values. I think my family values are relatively conservative, and so when I think of that term, that's what I think of. I think of the things that I try to teach my kids. And I'm not saying that only conservatives teach this to their children, but I think that that's something that brings to mind when I think of the term. So I think of working hard, trying your best to do the best that you can at everything that you try, and that's what I'm trying to bring to the table.
Mark?
I use the term conservative as opposed to radical. I think in terms of kind of the old-fashioned definition of conservative, meaning you're very frugal, you don't waste things, you want to be efficient, you want things to operate the way they're supposed to, you don't take risks with things that are radical in nature. That's the definition I've used. I'm one of those people, I had an NRA sticker on the back of my Prius. I'm kind of a contradiction in terms that way. I don't like to waste things, and so I drove that kind of a vehicle for a long time. And that's kind of the mindset. It's applying common sense, being stable. That's another part of, I think, of being what my definition of conservative is being stable and predictable, which is something you want from a judge. Because when you have unpredictability out of the judge, it's very hard for attorneys to advise their clients on how to approach things and what they should be doing in their circumstances. So when I use the term conservative, it's in the old-fashioned sense.
Thank you. Steve?
Well, the judicial rules of conduct specifically say that in judicial elections, you shouldn't be appealing to partisanship. And when you're using buzzwords or dog whistles, that can send the wrong message to certain people. So staying away from certain words and dog whistles is wise, and it's required by the rules. So people can speak about judicial philosophy in more detailed and more nuanced ways than simply using dog whistles or buzzwords like that. So I think candidates need to be real careful about putting that in flyers on their websites and the like, because one, it's prohibited by the rules to appeal to partisanship, and two, this position is for everybody, conservatives and anyone else who has any other description that's out there. So I think we need to all be careful about how we use those terms, especially in campaign literature.
James?
I think conservative captures something about judicial philosophy in that it denotes that someone's going to apply the law as written. And it also conveys a sense that there's going to be predictability and impartiality for all parties that come before the court. So again, I use the word conservative on my website, and again, that's what it's to denote. Characterizing it as a dog whistle seems like a stretch to me, but again, it's to denote judicial philosophy and applying the rule of law.
Thank you. All right, Mark, you'll be next. Who of you have had experience on the bench? I kind of think we talked about this, but maybe we could go through that again. And we'll start with you, Mark. Please explain it, I guess, is what they want to know.
Places?
Please explain.
You got to read the question over again.
Okay.
I'm sorry.
Who of you have had experiences on the bench or experience on the bench? And if so, please explain. I think
I'm
you did
confused here. Is it asking if I've had experience on the bench?
each of you. Have you?
No, I have not been a judge. I've been a lawyer for 32, going on 33 years. I have not been a judge. None of us have been a circuit court judge. That's why we're running for this position. I have argued in front of hundreds of different judges here in the state of Wisconsin. I know I've appeared in more than 40 different counties over the years. I think I said I've been in front of 6 different judges in Ozaukee County. I couldn't tell you how many different judges in all of the counties surrounding here. So I'm not quite sure I understand that question, because none of us have been on the circuit court bench, or we wouldn't be running for this position right now, I guess I would.
Okay,
So
you know
I'm a
what?
little bit confused by the question, but part of it, if I've got 30 seconds left here, part of it is the experience of being in front of other judges. One thing I'll talk about too is I've argued in front of the state Supreme Court, argued in front of the Court of Appeals, 7th Circuit Federal Court in Chicago. I think I have a lot of experience with being in front of different judicial settings and understanding the different procedural situations and all of the evidentiary rules that a judge is supposed to apply.
Thank you. Steve?
Well, yeah, I guess I have 10 years. I know I have 10 years of judicial experience in the municipal court level, which obviously deals with civil ordinance violations here in Wisconsin. So it's a court of local creation, and I've been doing that for obviously 10 years. And yeah, I've had experience with judges in many of the counties in the state, and especially in the suburban area. So good opportunity over 20 years to see judges that do a great job, some in between, and not such a great job. So.
All right. James?
My most intimate experience with the bench has been as a law clerk to Judge Lee Dreyfus on Waukesha County. That was a circuit court dealing with civil claims. And then also clerking for Justice Wilcox, being in his chambers, assisting him with deliberations related to cases, researching issues, drafting opinions. And that's what's really shaped, my view of the judiciary and the important role that judges play in our society.
Angela?
I have not been a judge before. I have appeared before many judges throughout the state and also in Illinois. I've appeared before the Court of Appeals and the Supreme Court and argued cases there also. I've been appointed by judges as guardian ad litem to give my recommendation on what I think is best for children or for other people with special needs. And so that's where that experience comes in.
Thank you. This is a little different. This is an opinion. Do you think our judicial system has room for improvements? And we'll start out with Steve.
Well, of course, there's always room for improvement. The Supreme Court has an Office of Judicial Education that applies to circuit courts and municipal courts, and every time we have seminars, it's eye-opening. There's a lot to learn. No one can know everything that you need to know. You need to be curious and open to continuing to improve yourself, learn, so personally, judges have lots of room for improvement. And I would say being humble is key, because sometimes I've seen it, judges, we lawyers call it black robe syndrome, where they sometimes get arrogant and they forget that they need to continue to learn. They need to be humble before the law, and continuing to improve oneself is obviously a big part of that.
All right, Angela?
James.
You got
Oh, I'm
James.
sorry, James. Why do I do that to you? I'm sorry.
No problem. I think I think our judicial system is the greatest in the world. And I think judges play a critical role in that. I think the events of the past couple of years in Ozaukee County have highlighted that there is room for improvement in Ozaukee County, that we need a more professional approach. We need a judge that will come in without having courthouse constituencies that are continuing the fights that have plagued the courthouse. So I think that's one area where whoever is elected to this position, they can make a large improvement to Ozaukee County's judicial system.
Angela?
I think the judicial system in our country is great, but I think there's always room for improvement. You've got the whole system overall, you've got our statewide system, and then you have the system in our specific county. And as I mentioned at the very beginning, I'm running because I think I can improve things. I want to improve things. I see the potential that we have, and I want to work hard to bring that to the people that walk through the courthouse doors.
All right, and Mark, you want to answer that too, please?
Yes. Structurally, we have a very, very fine system. Obviously, like a lot of other things that have to do with governmental type of entities, sometimes the execution of that is what gets lacking over time. My experience with a lot of the jury trials is you get jurors in there who have a real sense of duty and they want to do the right thing. And it takes a good judge who's got experience and has dealt with them before in those types of situations to allow them to do what they're supposed to do, and that is hear the evidence and determine the truth. And my experience is I have a lot of faith in juries. You know, my advice, I would always tell my clients, you want a jury trial, you don't want a trial to the court. Because unfortunately, when you have one person deciding things, they can't get away from their biases. But if you have a jury of the peers, and part of being a judge is managing that, explaining to the juries what their role is so they know how to properly process the information in the correct manner and reach a good conclusion.
Thank you. All right, we're coming to the end of our forum today, and we want to thank all of you for submitting your questions, but we didn't get to all of them, but some were very similar, so I hope we covered most of that. Now we have the point in the forum where each of the candidates gets a few minutes, 2 minutes, to one more time tell what they stand for and the message that they want to leave with you tonight. And James, it's yours. You start.
Yeah, well, thank you again for coming. And, you know, I think the thing I want to leave you with is that I had the opportunity to work for a great judge in Justice Wilcox. And there are 5 things that I took away from that experience. And I think that my experience since that will allow me to excel in these areas. And those 5 things are: 1, to be impartial. Knowing the importance that everyone should get a fair shake when they're in front of you. It's not about what courthouse constituency you're a member of. 2, it's being professional, being courteous to everyone. That may sound basic, but I think that's very important in a good judge. 3rd is intellect, being able to deal with complex issues, decipher the decision points, make a decision, and then explain in a clear manner why you made that decision. 4th is a commitment to process. As a judge, you're adjudicating a lot of cases. You need to be disciplined so that you can be responsive to the parties and to the public. And then finally, optimism. As I mentioned, I think we've got the greatest judicial system in the world, but judges deal with very challenging circumstances. People are in front of a circuit court judge because it's a significant issue in their life. And that could be in a criminal setting or a civil setting. So that can be very challenging for a judge to deal with those situations, but to retain that optimism that we have a great system and that our judiciary keeps our community safe and allows people to prosper. So again, I thank you for coming, and I've really appreciated this chance to tell you a little bit about my candidacy.
Thank you. Angela.
I hope you can see from our discussions tonight that I am passionate about helping people understand the law. I love interacting in this way with my clients, even though it can be difficult. Because as we've talked about, the law isn't always what people want it to be or hope it to be, and my goal is to help them understand what the law is, and if I can, why it is that way. As a judge, my reach could go beyond what I can do representing individual clients. One of my biggest frustrations is when the rules are not followed or when the rules are applied differently to different people. As a judge, I'd have the opportunity to address this enforcement in a much more powerful way than I can as a practicing attorney. One of the themes of my campaign has been integrity. And when I talk about integrity in a judge, to me that means that impartiality and respect that are essential for justice. But not only should each judge have integrity, I also want a justice system with integrity, which requires cohesion and solidarity to unify the administration of justice in our community. To do this well, it takes communication between the judges, the staff, the sheriff's office, our county departments, and many, many more. I'm confident that I could work well to serve the county. My very personal call to run for judge is a response to what I have seen firsthand in our courthouse. I want to improve our county. I cannot sit by and not take action when I see how much better it can become. I want a judge that will work hard, that will be prepared, that will listen and be fair. I want a judge that will study and apply the law. I want a judge that will be respectful to the litigants and those that work in the courthouse. I want a judge that has the patience to listen, but also has the ability to make difficult decisions without hesitation when necessary. I want a judge who is clear and will explain her decisions. I believe we have a responsibility to step up when we see how we can help. I'm asking for your support, and I'm asking for your vote. Thank you again for listening and for coming out tonight.
Thank you, Angela. Mark, would you like to tell us?
Due to my mistiming of how much time we had at the initial thing, I did not get a chance to talk to my wife of almost 30 years. We'll be married 30 years in June, is here tonight. My youngest daughter's here as well, Addie. She was the reason we moved to Cedarburg. We needed to move out to a community. This is the community we picked 23 years ago to raise our children in. My oldest daughter, Emma, my son, Christian, they were all very active in the Cedarburg area community and had a great upbringing, which is why we really love this community. Now, with regard to the attitude as being in what partly brings me to the whole process here of running for judge, and I got to tell you, I'm a non-partisan person in the sense that years ago I worked in the state legislature when I was an undergraduate student, and I saw firsthand how legislation worked, and it was not a very pretty sight. I really have had an aversion. I've had an aversion to politics because what I saw happen frequently is people had to compromise their ideals to accomplish things politically. And I've had an aversion to it. I always vote, don't get me wrong, I vote in every election. I have a civic duty to doing that. I've always been responsible in doing that. But until this election, I have not wanted to be a participant in a process like this. And it's a very difficult process for me to actually get involved with. But I do want to talk about, I've always viewed the legal profession as that, as a profession. Some people approach it as a business. And I've always thought the higher thing is a profession. We've seen it in other things. We've seen it in the medical field. We've seen it in engineering, other places where different types of professions have lost their meaning of what it was. And part of this is we need to reinstill those values.
Thank you. Steve?
Well, again, thank you to the league for a really well-run forum, great questions. People are obviously engaged with the real topics that are facing the court system. So again, I mentioned earlier, you're the HR department, you're making this hiring decision for one of us, and I just want to break down some of the things I think are key. In my time as a judge, I've tried and presided over 1,000 trials of all different types, OWI cases to basic traffic-related cases and juvenile cases. I've encountered thousands and thousands of people over the years. Our court handles 20,000 different matters a year. So over 10 years, I've encountered thousands of people. I've treated them all fairly. I try to be approachable as a judge, decent and fair to everyone who comes before me. And I believe that is key to making sure that people feel that they are participating in a process, not having the process imposed upon them. As I mentioned earlier, I've had this insight, this window into what's going on with young people, with drug issues, with mental health issues, with poverty issues that do happen here in Ozaukee County. So I'm particularly well situated to see that. I've got a great record of honoring the Constitution, suppressing evidence when law enforcement makes a mistake, not rewarding them for stepping outside constitutional bounds. I have a track record of enforcing the Constitution or honoring the Constitution in a First Amendment case, a religious freedom case in one of our communities. I believe wholeheartedly that being a guardian of constitutional rights is my role. Experience in both criminal and civil jury trials. Again, this is something that the court will be called upon, a judge will be called upon to do possibly on day one, and I have that experience. Deep experience with drugged and OWI cases continues to be a problem. While OWI alcohol-related cases are flat, drug driving cases are through the roof, and I have deep experience there. It continues to plague the community. So I thank you for your consideration, and I welcome your vote if you're willing to give it.
Okay, thank you. This concludes the forum. I hope it's given you, the voters, the information that will help you cast an educated vote on February 19th in the primary and then again on April 2nd in the general election. You could always check your municipal hall to find out the hours for in-person early voting. I want to thank the county administrator and his staff for putting this together and preparing this room just wonderfully for us. And if you appreciate what the League of Women Voters has provided by conducting this forum, perhaps you'll consider becoming a member, making a donation, or offering your services at another time. Thank you, candidates, for giving us your time and your thoughts this evening. We appreciate it.